Welcome back to a closer look. The legislature has enacted a record number of amendments to the Constitution, fundamentally reshaping the roles, functions and responsibilities of the judiciary. This overhaul signifies a major transformation in the judiciary's duties and powers.
In a bid to ensure a lawful environment for the economy to thrive, the government is embarking on a significant overhaul of the court system in the country. This move comes as part of a fundamental change aimed at enhancing the efficiency and effectiveness of the higher courts. One of the key changes proposed is the substantial increase in the number of judges from the current ceiling of 40 to 200. This increase is deemed necessary to address the long-standing issue of backlogs and delays in court cases. Justice and Attorney General Minister Niningi said presently the ratio of judges to cases stands at an average of 1 judge to 200 cases, leading to prolonged legal proceedings and delays in justice delivery.
In the past, they put ahead. Now this time, we're selecting the people. We approach them individually. If we think that judges, they think that they present well, you are worthy to be considered, and they consider them. At the moment, now we have confirmed 43 judges. That is including the nationals as well as foreign judges.
The proposed restructuring also entails a major overhaul of the roles and responsibilities of the judiciary, with a record number of amendments to the Constitution expected to be introduced by the legislature. These amendments aim to redefine the functions of the court and streamline their operations to ensure greater efficiency in dispensing justice. The Department of Justice and Attorney General Secretary Dr. Eric Kwa emphasized the importance of the proposed court restructure in addressing the pressing need for more judges to handle the growing caseload. Dr. Kwa expressed optimism that the proposal, once presented to Parliament, would garner approval, paving the way for the implementation of the much-needed reforms.
Constitutional amendment to restructure the higher courts. The proposal to restructure the higher courts began in 2010 when the judiciary realized that they are dealing with a huge or large number of cases, and the bottleneck is between the Supreme Court and the National Court.
However, the approval of the court restructure would necessitate several amendments to existing laws in the Constitution. These amendments are crucial for providing the legal framework to support the proposed changes and ensure their effective implementation.
And then we didn't have enough judges. The ceiling at the time was 40. So 40 judges dealing with over 11 million people. And so the proposal was to insert an appeals court. So that proposal went before Cabinet in 2013. The Cabinet did agree. Then we did start the drafting of the amendments. That amendment went to the Parliament in the 2012-2017 Parliament. And in that Parliament, they only went for the first reading, the first vote, and then it stopped.
Parliament is set to take its final vote on the proposed court restructure during this month's sitting. If approved, the restructure is expected to bring about significant improvements in the judicial system, reducing backlogs and enabling the courts to serve the people more effectively. Adding on to that, Minister for Justice and Attorney General Niningi said they will also work closely with the change from court systems data recording from analog to digital.
Very advanced, it's almost completed, the transition. So I'm happy with the Chief Justice and his group is doing it. And the new court will be fully functional then.
We will now take a quick break, and when we return, we will take a closer look at an effort by the Papua LNG and PNG ports to preserve and grow mangroves.